Longmore, we're very grateful indeed to you for coming today. First of all, I hope to express some general views about the need for this bill from your point of view, and also to answer or comment on any of the answers or questions you've already heard from members of the committee.
Yes, well, thank you, of course. I echo Professor Clark's enthusiasm for the bill. It's been a long time since the law of insurance has really parted from what has been accepted by respectable insurers as being good practice. And that has always seemed to me, at any rate, a very undesirable state of affairs, that the law on any topic should in effect be sidelined by adopting practices which are inevitably more beneficial to the consumer than the law is at present. And quite apart from the fact that good practice can't always be relied on, it gets worse and worse as the years go by. The laws set out in 1906 has been with us, of course, for a very long time. It's only after the Second World War that the consumer situation really began to rear its head. But I think it was back in the 50s that insurers, respectable insurers, felt impelled to adopt what were called the Statements of Insurance Practice. And they have been updated over the years. But they are effectively an acknowledgement that the law is defective in the areas which this bill covers. And the Law Commission has now done sterling work on two separate occasions, back in 1980 and now, in bringing this to the attention of Parliament and strongly urging Parliament to do something about it. And I think it might also be worth saying that the United Kingdom, England in particular, but the United Kingdom as a whole, is recognised worldwide as being a very major centre of insurance. And what we do here is looked at with great interest by other countries, particularly in the Commonwealth. In this respect, as Professor Clark said, Australia is actually well ahead of us in the sense that they have enacted an Australian contracts law which echoes some of these proposals. As far as the EU is concerned, I fear I can't answer in detail questions. I don't know what the situation is, and Professor Clark knows much more about it than I do. But if one waits for a harmonisation from the EU of insurance law, one is liable to wait forever. That is one reason why nothing happened on the first occasion these matters were discussed in 1980, because it was said by Parliament then, well, is it really worthwhile having law reform here when a directive is impending? But it never came. And we ought to, I think, have the courage of our own convictions and do what is right for us.
Well, I think that's, if I may say, so very helpful, Lord Justice. Now, yes, Lord Sir.
Well, sorry, you haven't even invited us to.
No,
I mean that's enormously helpful, Lord Justice Longmore. But can I press you, because it's, I mean, as you've heard a bit this morning, and in our previous discussions, the committee has been very interested in the question of codes of practice and how they relate to the protection of consumers under the present law and this prospective legislation. It is quite clear that the Financial Ombudsman takes into account industry codes of practice, and of course here we're principally talking about the ABI code of practice, but I would be interested to hear a bit more, as I'm sure the committee would, about the approach of the courts to codes of practice, and particularly I'm picking up Baroness Kramer's particular point on genetic testing. I mean, if, for example, an insurer asked a genetic testing question essentially in breach of the code about genetic testing, and the consumer either failed to answer or gave an incomplete answer, what sort of approach would the courts take? So both the general question of industry codes of practice and reliance by the courts, and specifically on this very difficult area of genetic testing.
Well, the formal answer to that is the codes of practice are not the law of the land, whereas the Marine Insurance Act is. And it's been said that it applies to insurance other than marine in all the areas we're talking about here. And so a court is obliged to apply the law of the land. It can't say, well, the law of the land is one thing, but this code of practice says a respectable insurer should not take this point, or something like that. And if push came to shove, the court would have to just apply the law. If, therefore, an unreasonable question was asked, and a false answer given, the question being contrary to the code of practice, a court would have to accept that. Of course, there are ways in which these things tend not to come to court. If it's a clear breach of the code of practice, it will be thrashed out before it comes to court. And the insurer almost invariably will say, well, actually it's not a breach of the code of practice, because if you look into it in detail, then it isn't. We've all known cases where judges have lent on insurers. If a case has come to court, I remember Mr. Justice Donaldson, for example, later Lord Donaldson, Master of the Rolls, leaning very heavily on an insurer he thought was taking a non-respectable point. And the force of his authority was such that if he said, I think you ought to go away and settle it and I will give you 20 minutes, often that happened. But even he couldn't disregard the law of the land. I hope that's an answer.
Could I ask you, what is likely to be the effect of this bill, if it's enacted, on the overall cost of litigation involving consumers?
That's very difficult to predict, isn't it? I would hope, with some grounds for that optimism, that overall there would be less litigation as a result of this bill, because if an honest representation was made, then insurers will have to pay. If it's careless, then there'll have to be an adjustment, let's call it. It's quite difficult to mount a case of dishonesty unless the evidence is there. And it happens now, of course, to some extent, that insurers will accuse an insurer of being dishonest, and usually they won't do it without fairly solid grounds. Those can be difficult cases to fight and expensive cases to fight, but I would hope that this bill would actually make litigation less likely, and therefore the overall position would be beneficial.
Once again, that's very helpful. Yes, Lord Davis, I think, had a question.
Lord Justice, how much litigation has come before the courts in the last few years in the area of consumer insurance, which is turned, among other things at least, on the issue of full disclosure, absolute good faith?
Well, a bit. It happens mainly in the county courts as far as consumers are concerned, of course.
Right.
And I'm afraid I don't have very much experience of county court litigation. I have a bit at the bar, but since being on the bench, I've not sat in the county court. I think that there have been cases, not an enormous number, where insurers have stuck to their rights, and occasionally cases from the county court do come to the Court of Appeal, and the difficulty, as I see it, is not so much to pinpoint cases which have come to the court where an injustice is done on the present law. It does happen, but quite occasionally. The problem, as I see it, and I think this is fully threshed out in the Law Commission report, is that the current law gives insurers a very strong negotiating position, and the consumer, faced with an argument on the law, won't necessarily give up right at the beginning, but he'll very readily accept a compromise offered by the insurers, and so the courts don't see it. So certainly the Law Commission has given 2 or 3 examples in their even in their summary of that report of where this has happened. And so although one can't say that there have been an enormous number of cases where the law has been applied unjustly, it's the what is might call the submarine effect that is so damaging, I think.
Lord Hodgson?
Turn back to reasonable care again, and the bill provides in 4 examples of things which may need to take into account in making a determination whether a consumer is acting reasonably. I see nothing about proportionality of the questions that are being asked. My concern is that as the insurance companies find it more difficult, are not allowed to ask open-ended questions, you will get lengthy questionnaires of highly specific questions. Now, I quite understand that if you're insuring someone's life for 10 million quid, that's one thing. If you're renewing my insurance motor car for 400 quid, it's another one. And do you think it would be better and helpful to the consumer and whose interest this bill is trying to assist if there was a proportionality sentence relating to the seriousness of or the quantum of the insured sum being sought?
Proportionality as to the number of questions that are being asked. Yes. Well, I don't see anything wrong with that. I slightly hesitate because it would be very prescriptive to say a proposal form may not ask more than 15 questions. It would be an odd thing for an Act of Parliament to say, really. But I wouldn't be against it, no.
Ms. Kramer?
Thank you. I would like to just go back to the this question of the bill and codes of practice. If I understood correctly what you said earlier, judges being sensible people would pay attention to codes of practice, that either on the grounds that the bill is silent on them or frankly despite the bill, because they're sensible people. But that it does seem a rather unsatisfactory way to leave a new piece of legislation. The objections that I've read from the AIB on having any reference within the bill to codes of practice has been on the grounds that they as an organisation don't feel they should be put into the position of making law, if you like, and they seek flexibility and they don't want to have to draft things in a particularly legalistic way, etc. And I can understand where they're coming from in taking that kind of position. But would it be your view, looking again at this reasonable care provision that sits in the bill in clause 3, it is, as my colleague said, that it has 4 examples, the following examples of things which may need to be taken into account in making a determination under subsection 1. And it poses 4, as it were, answers, including, how clear and how specific the insurance questions were, etc. If there was something in there that said that added to those examples of items to be taken into account were relevant industry codes of practice, would that have the effect of making those codes of practice in effect law? And would it put on the AIB and others the kind of burden which I described earlier as the heart of their resistance? I mean, would that be your opinion? Or would you think it would indeed continue to have its more relaxed status that it currently has?
I think it would put a bit of a burden on the ABI or whoever was drafting the codes of practice. If one started referring to codes of practice in an Act of Parliament, they
even
would
if it was
be
only as an example of reasonable care.
I think I still feel hesitant about putting it into a statute. There would be no objection if a case came to court, no doubt, for the court to be informed as to what the code of practice was at any particular time. It wouldn't be, there's nothing here, I think, prohibiting a court from taking codes of practice into account. So if it were relevant to have regard to a code of practice in assessing whether an insured has answered a question with reasonable care, then I don't see why a court couldn't take that into account if it so wished. But I think if there was a reference to it in the statute, it would quickly mean that the code of practice would itself become embalmed in stone in a way that a statute does, and I don't think that would be a terribly good idea.
Can I just follow that up slightly? Because the other direction from which I have a concern about this clause is that because it gives 4 examples, and not others, the question is whether those 4 examples then have a standing over and above, so that a judge reading this would say, well, actually, these 4 are the ones. Parliament has indicated very clearly this is where our attention should be, and therefore other matters, which in the past might have been treated by judges as on an equal standing, now drop into a secondary role. So, for example, it says, one of the examples here is how clear and how specific the insurance questions were. That's Clause 3, Section 2, little mini-section, I don't know what you call this, mini-section C. So that now has particular status having been provided in the legislation. So, for example, would it now, in the position of the judges, be a far more significant item than, for example, an industry code that, say, prohibited questions on genetic testing?
Well, I do not think so. Judges are free agents. They look at what the statute says. It's only examples that are given.
But you just said a moment ago that if the industry code was used as an example, that would have all kinds of ramifications. So I'm just trying to probe a bit on...
Yes, well, I see that there could be an advantage in referring to codes of practice as something, as an example of something you can take into account. But I still remain of the view that I think it would be unfortunate if the statute actually said so, for the reasons that I've given. I don't think that's inconsistent with saying that they are, the 4 things given there are only examples, and judges will feel free to look at the position as a whole. It's quite an interesting point that you raise, in a way, because it's become a feature of recent statutory drafting. It's quite recent, I think, that Parliament gives examples of things that judges ought to take into account, and judges aren't terribly keen on it in a way. From a judge's point of view, if you have a discretion, you like to have an unfettered discretion. But as long as they are examples, I don't think your discretion is unfettered. Obviously, you look at what the statute says, you derive assistance from that, but you look at other things as well, and I don't think there's any serious risk of a 2-tier situation arising.
I think Lord Davies, and then perhaps lastly Lord Borry. And then I think we...
There's actually a double question. I take it that English courts would always accept jurisdiction where there was a dispute involving a contract of insurance sold in this country to a resident in this country, so irrespective of the provenance of the insurer. That's, you answered the first part of my question. On that assumption which I was making, is it not right that the present situation constitutes a considerable anomaly in the single market, and that this bill would go some way to removing that anomaly, that obstacle? Because, as I understand it, if you have an insurance product which is sold to a consumer in this country by a member of the ABI, then a different legal regime applies, and the members of the ABI are setting aside protection they had in the 1906 Act. But if in fact the consumer purchases the same identical insurance product but from a continental insurance company elsewhere in the single market, including indeed from a parent company of members of the ABI, they go directly to the Allianz or Generali or AXA or what have you. All those companies of course have subsidiaries in this country which will be members of the ABI, but the parents will I think not be members of the ABI. So there would be an enormous anomaly here, because the consumer and the unadvised consumer may appreciate this danger, would find that he was facing a different legal regime if he purchased from a subsidiary in this country, a member of the ABI, the parent company elsewhere in the single market. That's not how the single market should work, is it? And the effect of this bill will be, I think you've already told us, or Professor has already told us, Professor Clark, that to make the regime here much more similar to, closer to, but identical with the regime that applies elsewhere in the single market.
Well, it's not an easy question to answer in the abstract. If you make your contract of insurance with what I'll call a foreign insurer, even if it's an EU insurer, obviously you don't have quite the same security as if you do it with an English insurer, in the sense that...
A member of the ABI, it's an important thing.
Well,
not the residents of the insurer.
Yes, I follow that. Now, I don't know if there's any code of practice on the part of the ABI insurers which says that if someone is insured by an EU entity rather than a British entity, they will accept jurisdiction in England. I'm afraid I didn't know the answer to that. If there were, that would be a good thing. But in the absence of that, the question, there would be two questions. One, what is the law governing that insurance? And usually it is the law of the insurer's office, where the main head office of the insurer is.
Oh, well, that's the opposite to the answer you gave me to my first question. I said, would not English courts accept jurisdiction where the product was sold to an English resident? And you said, yes, the courts would. You're now saying that actually the law that would be applied would not be English law, would be the law of the insurer, which could be the law of China in the event that the law of the insurer was located in China.
I think you're quite right to pull me up there. As I say, there are two questions. One is what the law of the insurance contract is, and as English law currently is, I think I'm right in saying, unless you have a clause in the contract. Of course, you might well have a clause in the contract. If there's no clause in the contract, it usually is where the insurer has his main place of business. Now, that is an entirely different ballgame to the matters grappled with by this statute, and that can be a difficulty. The second problem is whether you can actually get the insurer, if he's a foreign insurer, before the court here. There wouldn't be much trouble if he was an EU insurer, I think I'm right in saying, that you could get the insurer before the court here, but there'd still be the question as to what law would apply. In the bill, in the draft bill presented by the Law Commission, I think I'm right in saying, there was a clause which said that you could not get out of the provisions of the statute by saying that some foreign law governed the contract. But I think that's actually been dropped in the form that the bill now is before your lordships.
So what would be the position? This is the obvious question now, in light of your answer, for which I'm grateful. What would be the position if the bill comes into force, comes an act of Parliament, where the insurer is a foreign insurer and claims on the principle that you've just explained that the law that should be applied should be the law applying in the location where the insurer is? So you then have some British court trying to apply Chinese law, or maybe more realistically German law or Italian law. Is that right?
That can be right. I think that's more realistic, because not many people, consumers at any rate, will sign up with a Chinese insurance company, one assumes. But they can obviously find themselves with a French or German insurer, and it no doubt might be a question, but it would be a much larger question, or a very different question from that which this bill tries to grapple with, as to whether one should be able to say that any English consumer should be able to sue in England. That wouldn't have universal agreement from foreign insurers, of course.
Lord Boyd?
I wonder, Lord Justice, if in addition to the doubts you've expressed about absorbing or putting some reference to codes of practice within the legislation which is before us, there is also the point that it could be regarded as an abnegation of responsibility to a body over which Parliament has no control, which is, of course, controlled by insurers, in other words, one side to the contract, and is generally undesirable for those reasons that one should have a reference of this sort in the bill.
I think some force in that, if I may say so, yes. It's hardly for me to say so, though. I mean, Parliament should surely face up to its responsibilities and not delegate it, so to speak, to outside bodies. But that is how, traditionally at any rate, our Parliament has proceeded.
Well, Lord Justice Longmore, I think we're all extremely grateful to you for all your very, very careful answers to our questions. It must be a long time since you've had to answer examination questions on the law of insurance.
It is a little way.
You've done extremely well.
And if I was, it was usually in the committee room down the corridor.
Thank you very, very much.
Thank you.
That, I think, concludes the public part of the... and we'll stay...